Hello everyone. So today we are going to discuss about Article 31C of Indian Constitution. So in the previous classes we already discussed about Article 31A and Article 31B. So here Article 31C, three important articles were the exceptions to the fundamental rights. So let's come to the deep discussion regarding the Article 31C. So here Article 31C, which was added by the 25th Constitutional Amendment Act 1971. Okay, so here it is a saving the laws which gives effect to the certain directive principles of the state policy. So we already know that directive principles of the state policy. So especially to maintain or to make balance between the rich and the poor, and to provide some facilities and privileges, advantages to the socially background people, and to maintain social and economic equality. Also, we have different approaches. Also, one of the main approach is a socialistic approach, and we already know liberal principles and Gandhian principles also. So whenever comes to the Article 31C, so here it is very important, and it is protecting some important laws in the socialistic principles of the DPSP. Okay, so especially, so here we already know about the directive principles of state policy contained in Part 4 of the Indian Constitution, and articles were extended from 36 to 51. So here we borrowed this important provision from Irish Constitution of 1937. Okay. So let's talk about the Article 31, see what it is telling. So here there are two important provisions under the Article 31C. So the first provision, it is providing that any law which made effect to DPSP, Directive Principles of State Policy, which contained Articles 39B and Articles 39C. Okay, so here they cannot be challenged on the ground of violation of the rights guaranteed by the Articles 14, 19. Okay, so here whenever the government is providing some important facilities, advantages to the people under Articles 39B and C, especially comes under the DPSP. So here those laws and those articles never be challenged on the grounds of the fundamental rights violation, Article 14 and 19. Okay, so this is the first provision. Let's come to the second provision. So these are the articles 39B and 39C. So 39B, which tells about the state shall direct its policy towards the securing the ownership and the control of the material resources of the community. So as per the common good, so it is distributing it, it is their right. And Article 39C also. So here the state shall direct its policy towards securing that the operation of the economic system doesn't result in the concentration of wealth and means of production to the common detriment. Okay, so these are the two important articles. So specified in these articles shall not be violated on the grounds of the fundamental rights convention. Okay, so it never be challenged on the grounds of Article 14 and 19. Let's come to the discussion of the 14 and 19. Article 14, which tells about the equality before law. Equality means everyone is equal before the law. But here, whenever comes to 39B and 39C, according to the government point of view, so they'll provide different resources to some people. So here then they never treat all persons equally, because rich persons they have to get wealth, but whenever comes to poor they are not able to get wealth with their own hands. So that's why here the government has a responsibility to take care about the poor persons rather than the rich persons. So here the government has to show the partiality between the rich and poor. So here on the basis of the right to equality, so the rich persons cannot able to go to the court to keep the petitions, especially on the basis of the Article 14 right to equality and the equal protection of the laws. Okay, and Article 19, which tells about the protection of six important rights in the respect of speech, assembly, movement, etc. Okay, so according to these important two articles, any person cannot able to challenge these articles as per violation of the fundamental rights. Okay, so let's come to the second provision. I already told two provisions under the Article 31C. So one provision was completed, so that is uh, there is no law which tells about the violation of fundamental rights, which are giving specific implementation to the 39B and 39C. Okay. So second provision which tells about that which gives effects to such policy not questioned in courts. Okay. So first provision never go to the question in courts. It means there is no judicial review. Okay. So the overall permission was given to such laws which are included in 39B and 39C under 31C article. Okay. So that's why here, if any government is going to implement such directive principles of the state policy, so here there is no question in the courts. Okay, especially on the basis of the 39B and 39C articles. Okay, it means the directly tells about here this article doesn't have any judicial review. Okay. So, but here the first provision was valid, and it was given permission by the Supreme Court also after inquiring all these things regarding the article and the Constitutional Amendment Act also. But whenever comes to second provision, which affects the judicial review of the Supreme Court, because here they excluded the judiciary system from the maintenance of such laws. Okay, so that's why it affects the judiciary system. So that's why on the ground of the judicial review, as actually judicial review is itself is a basic feature of the Indian constitution. It is a basic structure of the Indian constitution. As a basic feature or basic structure of the Indian constitution, we never take away such provision or such permission from the court system to involve any matter. Okay, so judicial review itself is a basic feature. It means the judiciary system can involve in any matter to inquiry such law is good or bad. Okay, so that's why here the second provision made as unconstitutional or invalid. Okay, especially this was judgment and declared by the Supreme Court in the famous case, that is Keshavananda Bharati case 1973. So this case is also known as basic structural case also. Okay. And next one, next amendment act was produced to this important Article 31C. So that is 42nd Constitutional Amendment Act 1976. So it was extended the scope of the above first provision of the 31C. So only two provisions under the Article 31C. First provision is any law which implement the socialistic directive principles of state policy under Articles 39B and 39C, it shall not be violated, or it shall not challenge on the grounds of the contravention of the fundamental rights, Article 14 and 19. Okay, so here the 42nd Constitutional Amendment Act 1976, it extended the power and scope of the first provision, it including within its protection any law which can implement on the basis of the directive principles of a state policy specified in the part 4, not only in the articles 39 B and C, but every article, every important provision under the umbrella of the DPSP, it can be freely expressed and freely can be involved in the 31C. Okay, so that's why here this is the judgment which was given by the Supreme Court, especially the power was given by the 42nd Constitutional Amendment Act. Okay, so here who extended the scope of the 31C article, first provision, 42nd Constitutional Amendment Act 1976 by the Parliament. Okay, but here whenever comes to Minerva Mills case 1980, the Supreme Court directly declared that this extension was unconstitutional and invalid. Okay, only they given permissions to the first provision under this article, but here only two articles were applied to this provision. But whenever comes to the total DPSPs, article 36 to 50 articles which are related to the DPSP, we already know. Okay, but here whenever comes to the 42nd Constitutional Amendment Act 1976, it given great and wider scope to the article 31C. It means any law can implement directive principles of state policy under fourth part of Indian Constitution. So that's why here it was invalidated and unconstitutional by the Supreme Court, especially in the famous case Minerva Mills case 1980. So from 1980 onwards, so the Article 31C first provision was not extended. Okay, only a few provisions it has contained, and it was not extended its scope because of the Supreme Court's judgment in the Minerva Mills case 1980. Okay.